Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Jessica Milan Peterson versus Alex Padilla. This is a case from the Supreme Court of the state of California. In this case, California passed a law that required everyone who wants to appear on the ballot for a primary election must provide 5 years' worth of tax records. The Republican Party was somewhat displeased by this requirement and sued the Secretary of State to have it not be enforced. The Supreme Court of California, in a unanimous decision, found this requirement from the state legislature to be unconstitutional under its own state constitution. So Donald Trump does not have to provide these tax records, even though the legislature said he does, because the Supreme Court of California says Donald Trump does not have to give tax records because it's a constitutional violation in the state of California. So, not the outcome I expected, not the vote I expected, but it's what happened. Let's read on. We must decide in this case whether portions of the recently enacted Presidential Tax Transparency and Accountability Act conflict with the California Constitution and are therefore invalid. At issue are the Act's provisions that prohibit the Secretary of State from printing on a primary election ballot the name of a candidate for President of the United States who has not filed with the Secretary of State the candidate's federal income tax returns for the 5 most recent taxable years. We directed the parties to submit briefing on expedited basis to ensure the matter would be decided ahead of the November 26, 2019 statutory deadline for candidates to disclose their tax returns to appear on the March 3, 2020 ballot. And here in a footnote, they note that several lawsuits are also pending in federal court that asserts this is a violation of federal law. But the issue here is whether it's a violation of state law, not federal law. The dispute before us turns on interpretation of the California Constitution, which states in part, the legislature shall provide for partisan elections for presidential candidates and political party and party central committees, including an open presidential primary where candidates on the ballot are those found by the Secretary of State to be recognized candidates throughout the nation or throughout California for the office of President of the United States. Petitioners cast the act as unconstitutional because it imposes an additional disclosure requirement for appearing on the presidential primary ballot. The Secretary of State, Alex Padilla, named as a respondent, counters that the Constitution does not prevent the legislature from prescribing disclosure prerequisites. In the respondent's view, by stating the legislature shall provide for an open presidential primary, it contains additional restrictions. And subsumed within this power, respondent argues, is the authority to enact neutral disclosure laws that provide relevant information to voters and thus enable the electorate to make a more informed choice. The current constitutional provision came into result as a result of what was called Proposition 4 from 1972. Its purpose was to ensure the voters at future California presidential primary elections would have the opportunity within each qualifying political party to choose among a complete array of candidates found to be recognized candidates throughout the nation or throughout California for the offices of President of the United States. The election code sections at issue here purport to make the appearance of a recognized candidate for president on the ballot contingent on whether the candidate has made disclosures specified by the Act. The additional requirement, however, is in conflict with the Constitution's specification of an inclusive and open presidential primary ballot. The Act at issue here provides, notwithstanding any other law, the Secretary of State shall not print the name of a candidate for President of the United States on a primary election ballot unless the candidate, no less than 98 days before the presidential primary election, files with the Secretary of State copies of every income tax return the candidate has filed with the Internal Revenue Service in the 5 most recent taxable years. Of particular note, the candidate also must file with the Secretary of State a signed written consent form that grants the Secretary of State permission to make a redacted version of the tax returns publicly available. So we see that this act, according to its terms, required them to turn over their tax returns to the Secretary of State and also required them to give a signed consent that this information could be made available to the public. One suspects that this was targeted specifically at Donald Trump, but let's read further. Within 5 days of receiving a candidate's tax returns, the Secretary of State shall make appropriately redacted versions of the returns available to the public on the Secretary's website. These versions shall be continuously posted until an official canvass for the presidential primary election is completed. And of course, once deleted from the website, they'll be gone from the internet forever, because that's how the internet works. A Senate floor analysis explained in 1973, the Providence Journal Bulletin obtained and published data showing that President Richard Nixon had paid an astonishingly low amount of taxes in 1969 given his income for that year. After initially resisting calls for him to do so, Nixon eventually released his taxes and underwent an IRS audit. It had turned out he had improperly claimed an exemption of $500,000 for papers he had donated to the National Archives. Ever since this incident, it has become customary, though never required by law, for U.S. presidential candidates to release their tax returns. Prior to 2016, only one candidate, President Gerald Ford in 1976, did not do so. Ford released a summary of his return instead. To summarize the analysis that follows, we agree with the petitioners that whatever authority the legislature may have in defining how presidential primaries are to occur in this state, the challenged sections of the Act exceed such authority and are unenforceable. These provisions purport to exclude from the California presidential primary ballot any candidate who does not comply with the income tax return disclosure requirement, even someone who is incontestably recognized throughout the nation or throughout California as a candidate for the office of President of the United States under any reasonable construction of that phrasing. Because the relevant provisions of the Act condition a presidential candidate's placement on a primary ballot the compliance with additional requirements that is concededly not a recognizable measure of whether the candidate is recognized as such throughout the nation or California, it conflicts with the rules specified in our Constitution and for that reason is invalid. We hold that Elections Code sections 6883 and 6884 are invalid under the California Constitution insofar as they purport to require someone who is recognized throughout the nation or throughout California as a candidate for the office of President of the United States to file with the Secretary of State federal income tax returns as a necessary condition for appearing on the primary election ballot of a political party that has qualified to participate in that election. In accordance with this holding, let a peremptory writ of mandate issue that directs the Secretary of State from refraining from enforcing the sections, and our judgment is final forthwith. So that is the end of the case of Jessica Milan Patterson versus the Secretary of State of California. In this case, we learned that the legislature passed a requirement that any candidate for a presidential primary must disclose 5 years' worth of taxes, and a redacted form that excluded such things as Social Security information and other address kind of data was to be posted for the public. This ostensibly applied to all candidates, but I think we can reasonably conclude it was probably targeted specifically at Donald Trump, which, as we noted in the opinion, was a bit of an outlier in not providing his information voluntarily. However, and somewhat surprisingly, the California State Supreme Court ruled unanimously that this requirement was unconstitutional because the state constitution required that everyone be on the ballot who is generally recognized without more qualifications, and therefore the Secretary of State putting additional qualifications as a requirement to be on the ballot was unconstitutional under California state law. So Donald Trump, perhaps despite the legislature's wishes, will be on the primary ballot in the state of California, and that is the end of this case.